open up and let's get to some of your questions that you've submitted. And then for those of you that are on, if there's type in the Q&A section. This is designed to be able to answer your questions. And we just had a couple submitted to us yesterday in preparation for this. So somebody's saying, I'm thinking of doing a will. I only have a home, a car, a small business, and a job. Should I do a will or a living trust? That is a really good question. And I think most attorneys out there would say, do a will. But you get that advice even on multi-million-dollar estates. They say, just do a will, not understanding the game that the will is directions to the probate judge as to what to do with your estate. And not knowing that they really want to take 6 to 10% off the top of your estate for walking everything through probate. But on small estates, and every state has a different limit. Most of them start at around $50,000. The average, I'd say, is 75 to 100. On small estates, the probate judge in your state doesn't want to deal with your estate unless there's really a bad feud over who gets what. They really want little estates. Just don't worry about them. Just take care of them. And so a will give direction to the probate judge, but it'll be a very simple thing. And the executor of the will should be able to handle anything on a small estate. It's when we get over that limit. I think in Utah it's $100,000 if you're overall estate. Now that includes anything that's going to go through probate. Life insurance generally doesn't go through probate because there's a clear title to who's the beneficiary, unless the beneficiary is not around anymore. On a IRA, that usually avoids probate because there's a beneficiary. The IRA is a trust, but if that beneficiary is not there, or if somebody disputes it, then they're not a legitimate child, I'm the legitimate child, then those things would be figured out in probate court. And if there's a trust, those assets also avoid probate. So probate is really for the things that were left in kind of limbo. And if those assets are under $100,000, or whatever your state will allow, then a will is probably sufficient. Jay Minton used to always tell me that you always want one asset, one or two little assets of the estate to go through probate. So, because it ceases all creditor claims. They advertise, remember old English law, hear ye, so-and-so has died, you've got 6 months to bring your claims, or 3 months, or whatever time period, and then probate is ending. So even if we ran a car or a small bank account through probate, it ends all creditor claims, and then the beneficiaries, the children, whoever's left over, can rest easy knowing that no more claims can come against this estate. So in your case, I think a will may be the appropriate tool. I'd like trusts whenever we're over that exclusion amount, or things in your state that are going to go through probate are over the exclusion amount. I hope that makes sense. All right, I have a network marketing company I belong to. How should I set myself up? Well, hopefully you set yourself up well to do well in your business. But I think we're talking first, right? Legal structures.
Yep.
Most small network marketing companies would set themselves up as an LLC, taxed as an S Corp. We really like C corporations when I can control the amount of money that goes into it. It manages my rental properties, and I need about $40,000 worth of medical expenses and other stuff, and magically the management fee ends up being $40,005, showing a $5 profit at the end of the year. Yes, there's going to be double taxation on that $5. Live with it. I like C corps when I can control the money, but when I've got an MLM and you're looking with stars in your eyes, and maybe this is going to take off, and maybe you've got the stars align and you're going to be a multimillionaire, and I can't control the income stream that comes from this. Almost always we'd like S corporations for that, because I can't spigot the money. I can't control the money. If it comes to me, I like the ability to shift some income from salary over to dividend and avoid the self-employment taxes. Okay, next question. I own a property in Florida and Nevada. 3 are paid off. I own a property in Nevada. 3 are paid off and another is almost paid off. They are in my name and I'm afraid of people finding out I own them. What should I do? Well, we could use, if first of all, I'm not a great big proponent of anonymity. I'm a great proponent of asset protection, and some people think if they can't find it, then they can't sue me. But if you do something wrong and you're sitting down in a deposition, there's a judgment against you. There's a process called discovery, where under oath, penalty, perjury, you have to disclose everything you own. Now, if they can't see it before then, maybe they're happy to settle and not go to court. Not try it if they can't see that. So I understand the theory why anonymity is helpful, but Florida and Nevada both have really, really good laws for multi-member LLCs. But maybe this would be something I'd need to know a little bit more. Could we take your Florida property, put that in a Florida single-member LLC owned by a Nevada holding company or a Wyoming holding company? Nevada offers something that Nevada doesn't, or that Florida doesn't, and that is anonymity. They allow for nominee officer services. Think about who owns the great big casinos in Las Vegas and Reno. We assume it's the mafia, but we don't know that, because Nevada, Delaware, Wyoming allow for nominee officer services. So there could be billions of dollars in these Nevada corporations, and I don't know who owns it. And there's a degree of anonymity that's there. Sometimes that's not worth the price you pay for, because to have a nominee officer and to have complete anonymity, my guess is it's going to start at about $1,000 a year to keep up that veil. And then sometimes people do stupid things. They show up every month and collect the rent, or the property's been in your name forever, or you get a mortgage on the property, which is a matter of public record. And so there's a lot that you can do that screws this up. Remember, anonymity is not the goal. Asset protection is the goal. And if they see that you're structured properly, almost always that takes care of the problem. This isn't a separate LLC. It's got good insurance. I've got a different management company. I'm running it right. I'm not a slumlord. That'll take care of 99% of anything out there. Could we get you anonymity? You betcha. Absolutely. But that's maybe a different discussion. And then, Kendall, are we getting any more questions coming in?
Just a few follow-up questions on the estate planning one, but yeah, let's go through those first.
Let me do one more question that came in yesterday. I want to start a business and I have $150,000 equity in my home. Should I use this to start my business, and if so, how? Well, I can't tell you yes, you should use the equity to start your business, because I like having a free and clear house. There's something about that I like. Now, that's not a really good asset protection tool, because having my house fully encumbered makes it a very unattractive asset. Having it free and clear makes it very attractive for a plaintiff. And so somewhere between that, I don't like encumbering my home, putting a home equity line of credit to build a business, if I'm not absolutely sure that this is going to take off. So I can't answer your question. You're going to have to figure that out with your wife. And I don't know if it's a good idea, but Can you do it? It maybe is the question, not should I. I'm going to avoid that question. Can I? Yes, you could get a HELOC loan. Let's say $150,000 equity. Let's say somebody, credit union or a bank will give you, let's say $100,000 equity or a credit line. So then what you do is you've got the ability now to sign a check for $100,000. It's a HELOC. It's a credit. So they're going to keep a lien against your house for $100,000 as long as you've got the right to sign a check for $100,000. They keep a lien against your house. You're only going to pay the interest if you use the line of credit. Now, I use that line of credit and I start building my business. So the step you would do is get the line of credit, and then you would set up your business. An LLC, a corporation, S Corp, C Corp, I don't know, whatever you need to. So figure out what type of business structure do you want. Corporation, limited partnership, or LLC. And then figure out how to tax it. Set that up. And then take the money that you've taken out and contribute that to the new business. Whatever business structure you figured. And that would normally be considered either a promissory note or your capital contribution to this entity. That would be the most common way. Capital contribution. So you're taking the money out of the HELOC loan, you're taking it personally, and then you're personally contributing it to your new business as a capital contribution. That would be the most common way to set that up. But I'm not going to answer your question, should you? No, we're gonna have problems with your spouse if I answer that question. So you're going to stay away from that. Okay, Kendall, what else do we have?
So Anthony asked, how do you hide your mortgage on a property?
How do you hide your mortgage? Well, you don't. You signed for a loan in your personal name. You gave them all your it was a total recourse loan. You gave them the ability to destroy your credit, to take away, to garnish your wages. If you've already signed that loan, they're not going to release you from that loan until you pay it off. I don't know that now, if we had a commercial property or an investment property, we had set up an LLC, let that have time to season. So now that the LLC, the corporation, goes out and gets a credit line of credit history, and it has a Dun and Bradstreet number, a Dunn's number, and it establishes credit. It builds credit. You get your Home Depot card, and you get your Visa card, and your MasterCard, and whatever, and you use your credit well, and over time, your business establishes credit independent of you, but that takes time. And yes, and there are companies out there that will offer you a shell corporation with business established or business credit established. I'm not a big proponent of that, although I know that they exist. To answer your question, to get the loan out of your name, you're going to have to pay off the loan. I don't know any other way to do that. Kendall, any thoughts?
Well, I guess it's recourse versus non-recourse. What's the difference?
Non-recourse is they're looking only at that asset. So we do a loan. It's got a commercial property in it, and they're saying, yeah, there's enough equity in here. We'll give you the loan, and we see the cash flow coming in. But your name, your social security number are not tied to this. That's a non-recourse loan. A recourse loan, which is most likely what I'm hearing you have, is your name, your credit history, your social security, everything you own is tied to that. And they can totally destroy you if you don't pay the loan. Other than bankruptcy, you get really two options: pay off the loan or go bankrupt. But I remember co-signing on a car with my son, and now he's out of college and he's ready to go and he's got a good job. And I go back to the bank and say, hey, can I get my name off this? And no. Why would we release you? Yeah, I mean, you're paying the thing. We're not going to release you. You can pay it off, and then refinance it. But that's the only way to get your name off a loan once it's there.
So it's personal credit versus business credit. So when legal structuring, you can use business credit. You kind of explain a little bit, but so if you wanted to get a loan on your LLC, that'd be business credit.
Correct. Business credit is very different, and that will be tied to your EIN number, your employee identification number for the business. Where personal credit, that's going to be tied to your credit history, but there's no DUNS number. For a business, there's no Equifax or the Experian, or there's nothing there. So DUNS is the credit monitoring for businesses. So
It's interesting,
Dun
yeah.
and Bradstreet number.
It's a whole different ball game when you talk business credit. It's a whole different avenue. A lot of people don't understand that. You have everything, like you say, a Dun and Bradstreet number. You have a separate credit report, all the filing, everything's done through your business. So from an asset protection standpoint, if you get to the point where your business has a nice number, a nice history, like you said, seasoned, is that a good asset protection strategy to have business credit versus personal credit?
I think it's always a good idea to keep things out of your name. I like recourse loans, no, I said that wrong. I like non-recourse loans. Well, you're going to pay, a little bit more for a non-recourse loan because their only recourse is to come after that asset. But every bank, even though they tell you that they don't offer non-recourse loans, every bank does. If you bring enough to the table, there's enough cash flowing through, you've got enough equity in the deal, and they're in first position on that piece of real estate or whatever the collateral is, they'll always offer recourse and non-recourse loans. But they only tell you about the recourse loans. They don't tell you about the non-recourse loans.
I don't know, to me that's a really interesting asset protection strategy. We really don't go down a lot because most of us are real estate investors. We bought it with our own cash, our own self-directed IRAs, our own credit scores, their own mortgages, and there's a whole new world a lot of us don't even get into. Even with businesses, you have your own credit, your own money to bring into the business, start a business, but most times, this is why you see a lot of businesses. They get business credit, business loans, business investment, venture capital, all down to the business, which means they have no recourse to come back to you personally.
Correct.
Really kind of an interesting asset protection strategy.
It was interesting when we got this office. They wanted me to sign, and both Kendall and I, they wanted us to sign personal guarantees for that, and we went, no, I don't think so. Well, that's how everyone does it. I don't care. That's not how we're going to do it. We teach asset protection. We're not going to do that. So we prepaid 6 months in advance, and they went, okay, that's good enough. So they waived their regular. They've never done it before. The association that leases the property went, okay, you're bringing enough to the table that we don't need this to be a total recourse thing. But that lease was mean-spirited. You are not getting out of this lease. There's no bankruptcy. There's no act of God. There is not. You are personally responsible for that. And frankly, I wasn't willing to spend that to sign that. So anyway,
interesting. They said this is normal. This is what everybody does. So every business that comes in is, in fact, using their personal credit, not their business credit. For them, that's pretty interesting. That's really interesting to me. I don't know. Asset protection, guys. If you don't know what you don't know, right?
Yeah.
It's interesting.
So stay away from recourse loans whenever possible.
That's real interesting. All right. So we kind of go back to your question: wills versus trusts, right? And so we always talk about a trust avoids probate. A will pretty much kind of guarantees probate, right? And so people are asking questions about that. And if you're the executor of the estate, you kind of mentioned that a little bit, people think they have full control of the estate. How does the executor work? If you're made executor, we get questions a lot about that. Generally, what's the process there?
Well, okay, so there are some terms out there that are very misunderstood. There's a power of attorney, there's an executor, there's a trustee. And those, we kind of interchange those terms a lot, but they're very, very different. A power of attorney is good until you die. it usually springs into action upon incapacitation. Thus we call it a springing power of attorney. And we can, on a power of attorney, we can make it very limited in scope. Here's, Kendall, I'm giving you the power of attorney to sign this real estate deal and or work on this real estate deal while I'm gone to Europe next month. If I were going to Europe next month. But
let's go.
But here's my piece of paper. Or we give somebody a power of attorney to take care of our children while I'm gone and act as though we were them or they were us, and we can give it. We can limit that power of attorney to specific things, or limit the time period which it begins on this day and it ends on this day. My son was going to serve as a missionary for 2 years, and his power of attorney, he gave me power of attorney so I could do his taxes and I could do his banking and collect his mail and I had full, and it spelled out 15 or 16 things that I could do, but with a specific beginning date and end date, and then I gave the copy to the bank and I could do banking. Anyway, so that's a power of attorney, but it always ends, whether it's a medical power or a financial power, it will end at death. And now the trustee or the executors take over. Wills have executors, trusts have trustees. And once you kind of get that straight in your mind, that there are sometimes that you're going to have both. I've got a trust, but I also have a pour-over will that looks over, scans over my entire estate and says, oh, you forgot the tools in the garage. Or you bought this car right before you died. Or you bought this property right before you died. And so the will, the pour-over provision, what that means is it looks over, scans over, pours over your entire estate and collects all the stuff that you should have put in the trust but you didn't. That would be the role of the executor, because the will is taking care of all that. We use the will to take care of pets, to be guardian of minor children. Anything that the trust can't own, the will take care of. But then whatever was in the trust, the trustee wearing his trustee hat will take care of those things. Do I have hats for? I think I do. My
trustee somewhere.
I've got lots of different baseball caps that say trustee, executor, trustor, beneficiary, and sometimes you're acting in different roles, and so I use that. But the role of the executor is different, because their role is to walk things through probate, establish clear title to everything. The role of the trustee is just to act or to follow the rules, the babysitting instructions that were created by the trustor, the person who created and funded the trust.
And so there's some questions about deathbed creation. So basically then, how soon should you think about a trust? Because a lot of people think, oh, well, you know what? My mom, my dad's not doing so well, grandpa's not doing so well, let's create a trust. They're not going to make it till tomorrow. And that can be contested, right? So how does that work? People think about it last minute, too late. We all procrastinate. So how it's best to create sooner than later.
The biggest challenges of this is going to be capacitation or incapacitation. He wasn't of sound mind when he created this, or she wasn't. Or so that's an issue, and the other issue comes with the tax court. Let's say somebody has a $100 million estate, and 3 days before they start transferring, they or 3 weeks or 3 months, they've got terminal cancer, and so they start setting up these series of LLCs and series of limited partnerships, and donating to charity, and all in an effort to cut their estate taxes down. We found that in the Thompson case in about 2003, in the Hackle case in about that same period of time, where these estates are all those gifts and the limited partnerships and LLCs were unwound because clearly they were a deathbed creation, and the IRS wanted the estate to pay taxes on those. So we see deathbed creations when they're avoiding estate taxes. But if the person is of sound mind, they don't have to be in sound body. My uncle is 100 years old, sharp as a tack, but his legs don't work anymore, and he's almost in a wheelchair. But could he create his trust right now? Yep, mentally capable, and as long as there's people that will sign an affidavit that he is sharp as a tack, and I would do that for him, then it's not too late. But once they lose that ability, you either have a power of attorney or you're just too late. It's too late, and it is a deathbed creation, and it will be contested. Don't guarantee it if you're the only heir to the estate, but very likely that it could be.
And the great part is, so a lot of people think, I just have a will, I'm good. But another big reason to do a trust early, when you have capacity, do it early. But another big reason is privacy. So a lot of people are asking, we see all the time these trusts. I just read one this morning, talking about, again, brought up Elvis and Marilyn
Right.
Monroe, things like that, because they didn't have a trust, that it was all public knowledge and it went to someone who didn't even belong to the family sometimes, if you don't do it right. So it's then becomes public record.
Right. And like Elvis did have a trust, but he had $10 million of assets that still went through probate because those assets weren't funded into the trust. So not only is it important to have a trust, but it's really, really, really critical that we fund it. We put the stuff in. We take the assets and retitle those into the name of the trust. The trust can only control that which it owns, and if you didn't put it in there, the trustee has no power to control it. So then that would become the role of the probate judge and the executors and whoever wants to fight over the estate. And you're right, Kendall. Now it becomes a matter of probate or a matter of public record. Everything that's going to go through probate does become a matter of public record, and wills get contested generally at about 25% of the time.
Jeez.
Trusts, you don't see, trusts could be contested, but it's very unlikely. And there's clauses inside of a trust that says if you contest this trust and you're wrong, you're disinherited. And so there's some mean things that you could do. If you want to fight against the rest of the family, there's a penalty you're going to have to pay for this. And you can put that language into a trust where you can't in a will.
Yeah, that's, wow, 25%. So, and also, they're contested, but also we found out their stats showing that even if you went down to the corner attorney and you set up your trust, the funding is the most important part. If it's not funded, it could definitely not be working for you.
Jay Minton used to tell me this. He says if there was ever going to be a class action lawsuit against attorneys, it would be for all of the trusts they set up. So people, you go to your attorney, you pay $2,500, you paid $1,000, you paid whatever, maybe $10,000 to have this elaborate trust set up, and here's all my wishes, and here's how everything. But now we never take the house and retitle it in the name of the trust. We don't take your bank accounts and brokerage accounts. We don't take your life insurance policies and list them as a contingent beneficiary to the trust. My wife is my beneficiary, but now if she's not here, I want it to go into the trust. And we didn't make those ties. We didn't connect those dots to the trust. And so those assets will go through probate. Even though you set up a trust, but remember the trust can only control that which it owns. And those assets then, again, become a matter of public record, the time, the expense, everything associated with probate, because you didn't fund the trust. And it's assumed right now, according to the last stats that I've seen, is over 90% of trusts that are set up by your attorneys aren't being funded.
That's scary, which means a lot of the money you paid and work you did is not going to come into effect. That's kind of scary. We're pretty much out of time, but just on that note, just so we understand, asset protection for a trust and estate planning are totally different. You put your assets, title, like you just mentioned, titling your assets in the name of a trust. Do you have asset protection?
No, no. For the most part, the answer is no. A trust is a revocable living trust is a probate tool. It's here's clear title to this asset once I die, and that's really what it is. But a trust, because of the fact that it's revocable, I can change it, I can amend it, I can move the assets in and out every day if I want to, back and forth, and it's revocable, amendable. If you get into a lawsuit and you have access to what's in the trust, I just pull it out, or I take it in, or I move things around. If you have that much flexibility with this trust, then a judgment creditor also has access to those. It's not a separate legal entity. It's really a probate tool once you die. And so sometimes we'll use rental properties, we'll put those in LLCs, and then convey your interest down to the trust. We use a little paragraph called a designation of successor in interest. Upon my death, I want my 50% interest in this LLC to go to, and then you can list your trust, you can list a person's name. Yes, I've got a corporation over here, it saves me money on taxes, but all the stock is assigned to my trust. Or there's a designation upon my death, I want my 30 shares of this to go to somebody. And now it's a contractual obligation, there's clear title to those 30 shares, and they avoid probate. Probate is really for those assets that are going to be in limbo somewhere that nobody, and somebody has to decide who gets them. I've got a brokerage account and cash accounts in a limited partnership. And again, a designation of interest, so I own 60% of this limited partnership, but upon my death, that interest goes to, so then we make the ties to the trust.
Yep. So estate planning, using a trust, and asset protection, they don't go hand in hand. Make sure you plan that. Asset protection is very different than estate planning.
Very different. So we still do our tax strategies, we still do our asset protection, but I've kind of used the analogy that the trust now becomes your big popcorn Tupperware bowl. You never put it in the cabinet empty. You throw all the little Tupperware bowls, corporation interest, limited partnership interest, LLC interest. I take all this and then I stick it in the cabinet and go away, and somebody else is going to deal with it later. That's the trust. The trust is your big Tupperware bowl. Hope that makes sense to you.
It's great. Yeah, I can cover a different time. We're running out of time now, but maybe cover a different time. But trust. Everyone confuses that. That's my asset protection tool. It's not. That's great.
Yeah, that's a really good point, Kendall. All right, we are out of time. We didn't want to take too much time on your lunchtime. I hope this has been valuable. It's always fun to answer your questions. We'll be back next week. So bring your questions, and we'll do our best to answer them. Thank you. Have a great week. Thanks.